the purpose of the project is, well, so the premise of the project, I should say, and really the argument ultimately, is that Americans tend to associate rights adjudication with a few core paradigmatic features, that it's protective of political minorities and dissenters, that who are unable to obtain the favor of the legislature, that it's enforced coercively, typically with strong remedies, by federal judges, and that rights are, at least presumptively, absolute, to be overcome only in special circumstances, if at all. And most of the book is devoted to arguing that this view of rights is inadequate, and that it's indeed destructive in a modern pluralistic society in which the typical rights conflict arises out of good faith disagreement about relatively underspecified moral principles. There is within the book a critique of originalism, but the book is largely means to criticize both originalist and non-originalist approaches that are typical within the US as being too focused on whether there is a right, an essentially interpretive question when confronting a rights conflict. And as opposed to being focused on what the government's behavior is, whether it's appropriate, whether it's based on evidence, whether it's excessive, which are essentially fact-sensitive questions that are not primarily interpretive. The chapter is meant to show that the view of rights that I'm criticizing isn't just bad, but is also anachronistic, that it's not actually associated with something that's distinctively American, except as a contingent matter, dating back to roughly the 1960s. Much of the, well, let me back up a little bit. The chapter tries to emphasize that the framers' actual views about rights had within them elements that are worth recovering, but that's not in the service of more rights absolutism, but instead in the service of a more prominent role for a more fact-driven approach. And if I had to sort of put in a nutshell what the conclusion of the project is, it's that what should distinguish a rights conflict where courts give deference to the government from one in which they don't give deference to the government should not be a feature of whether there is a right at issue or a particular kind of right at issue, but instead should be a feature of what the government is actually trying to do and how it's trying to do it. So it's, again, a much more factually driven inquiry. So much of the chapter kind of goes through the Bill of Rights, provision by provision, to show an emphasis on preserving the decision-making capacity of political institutions, especially local political institutions and social institutions as well, not just political. So juries, legislatures, churches, primarily families, the militia, et cetera. The argument being that the emphasis wasn't on individuals holding rights against their communities, but of course individuals gathered in communities whose purpose was, among other things, to protect the rights of its members. So I'll just say very quickly what I say about each amendment, and then I'll just let Randy have at it. I guess I'll emphasize that most of what I write here is not novel. It's not intended to be new to me or new to the book. It's intended to bring together a bunch of observations, many of which have been made by others, to show that to essentially be a pre-buttal, right, to the argument that there's something strange about the kind of counter-narrative about rights that I'm trying to tell. So the First Amendment speech and press provisions were, as has been argued by many others before, were largely understood, not exclusively understood, but largely understood to apply to prior restraints. And that part of the reason for that is to ensure that decisions about injuries were made by juries and not made by the executive or the agents of the executive. The First Amendment religion provisions, likewise, are intended to protect state and local churches from federal establishment of religion on the premise that religious institutions, partly on the premise that religious institutions are communal in nature, that they were sites of governance, sites of local community decision-making, and not just purely religious in the more liberal-minded way we tend to think about religion today. The Second Amendment, of course, protects the militia. I tend to think that the debate between sort of the collective and individual rights view of the Second Amendment is overstated, just in the sense that militia itself would have been understood to be something that protected individual rights to bear arms, that's not inconsistent with saying that that the amendment protects the militia, because the militia itself was a law and order institution, and so is an aspect of self-governance. The Third Amendment guards the sanctity of the home and family in a number of ways, over which that's a site of social control by men. It's also, I think, designed to guard against standing armies, which would have needed to be quartered in ways that local militiamen did not. The Fourth Amendment inserts a jury in cases of search and seizure to determine questions of reasonableness, and it offers heightened standards for warrants in cases when a jury would not have been involved. And that's, again, not a view that's new to me, but fits within this pattern. The Fifth Amendment has various guarantees, but most of which are designed to guard the role of juries when liberty or property are at stake. That's due process, that's takings, that's self-incrimination, which if the government has the ability to coerce confessions, is going to corrupt the role of the jury. That's double jeopardy in preserving the jury's verdict. The Sixth Amendment guards juries directly, but also has some essentially anti-circumvention provisions. Speedy trial, public trial, and right to counsel are designed to inform the jury's, in some cases to inform the jury's verdict, and others to prevent other executive processes from substituting for a jury trial. The Seventh Amendment, and this is maybe a somewhat controversial view, but ties, and it's anti-doctrinal, but ties the civil jury right to the practices of states, so it preserves the right of jury trial as it would have been understood in state courts. The Eighth Amendment guards against, again, circumvention of jury verdicts through excessive punishment or fines. The Ninth Amendment is literally an instruction to judges not to read the Bill of Rights, to disregard those rights protected by the people. So it's in the literal service of exactly what I'm suggesting, which is that rights were normally protected by the people and that should be preserved, even against federal judges who are part of the federal government as well. 10th Amendment is a reminder that the Bill of Rights shouldn't be understood to enlarge federal power. And the point, again, is not that we should adopt a particular set of views about rights that privileges political decision-making because of the founding. I'm not making an affirmative argument based on what the founders might have thought about rights. It's to say that understanding rights in terms that protect a role for political institutions is not foreign to the American experience. And I'll leave it at that.